I am starting the recording and letting Ike know we can begin the broadcast. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5318. Ryan Noah Shapiro, appellant, versus United States Department of Justice. Mr. Light for the appellant, Mr. Tillman for the appellate.
Good morning, and may it please the court. This is Jeffrey Light on behalf of appellant Ryan Shapiro. This court has never squarely addressed the question of whether Rule 56D requires in every FOIA case that a plaintiff show bad faith before obtaining relief. However, in the FOIA case of Schaefer, there was no allegation by the plaintiff of bad faith, and yet this court held that it was an abuse of discretion to deny Rule 56D relief. When this court has considered the existence of bad faith, it's been
what was the issue in that? What was the date of that case you just cited?
Schaefer was decided in 1974.
In when? Sorry.
1974.
Well, the government cites far more recent cases, like Freedom Watch and Baker and Husseller, which are much more frequent cases, and they say evidence of bad faith is necessary in a FOIA case. That's what they hold.
Well, those cases are actually distinguishable because in those cases, the plaintiff's sole argument was that there was bad faith. So this court said, was there or was there not bad faith? In this case, plaintiff is not pressing on appeal a bad faith argument, but is arguing that the declarations were insufficient and that additional information was needed in order to fully oppose it. So this is different than a situation.
Mr. Light, I'm looking at you're arguing you're in the district court. You argue that the district court should allow discovery because party statements, and here I'm quoting you, give rise to the possibility of agency bad faith. That was your position in the district court.
That was one of our positions in the district court.
So how can you now say that the district court erred by requiring a showing of bad faith?
Well, we pressed
that was your argument in the district court.
Well, we pressed two bases for it. One was the issue of bad faith, and the additional one was the insufficient declarations. In fact, we said
but I was only focusing on your bad faith point. You're telling us that the district court erred by requiring evidence of bad faith, but you argued in the district court that there was evidence of bad faith.
We noted that there was, but we also said very specifically that evidence of bad faith was not required. And in our declaration, in which I went into what was required, I set forth that there was bad faith, but additionally, there were other reasons why discovery was required.
Could you, would you go on, and the time is limited, would you tell us what your best argument is about the inadequacy of the search? Would you please?
Separate from the discovery issue?
Yeah, separate from the discovery issue, yeah.
So in Campbell, this court made clear, as far as case law, in Campbell, this court made clear that a search of the CRS is not sufficient and that a separate search of the ELSER indices needed to be conducted. And in this case, as a factual matter, we never found out from the FBI whether the ERS or other systems were searched directly or not. And there's a big difference because there are different capabilities of the CRS search versus the ELSER search. And Mr. Hardy specifically said in his declaration, not all names of individuals contained in the ELSER indices can be retrieved through the general indices of the CRS. So for the FBI to then only conduct a search of the general indices of the CRS is not proper in light of the statement made in the declaration.
Mhm.
And I just ask, with respect to the 56D argument, do you have any authority for the proposition that not providing search words, search terms, or keywords entitles a plaintiff in a FOIA case to a deposition or other discovery?
So the standard under Convertino is, and what was dispositive to the court in this case, is whether the information was necessary. And this court very specifically in Oglesby said that keywords are necessary and used that specific wording.
But the remedy for that is another declaration. You didn't want another declaration. You didn't ask for a better declaration. You asked for a deposition. So what authority do you have for you get a deposition?
Well, we didn't ask for a deposition. We asked for an interrogatory, and we wouldn't have had any problem if the response had been a declaration addressing those questions as opposed to a specific sort of item by item response. But the general point is not that the court needed to give the specific relief that we asked for, but that it needed to grant us relief under 56D, which gives the court a menu of options. But the court didn't select from that menu. The court said no 56D relief is available at all if there's not a showing of bad faith. And that is not something that's been established by the text of the rule and is in fact inconsistent with the text of the rule, because if plaintiff had evidence of bad faith, they would simply win on the merits and there'd be no point in having discovery. The whole idea of Rule 56D is that the plaintiff cannot prevail on the current record.
I just have a follow-up question to Judge Wilkins' question about key terms. With respect to your request that focuses on names and organizations, the Hardy Declaration says that they searched using the name of the person or the organization, a phonetic breakdown, dates of birth, places of birth, and Social Security. So with respect to the names and organizations, could you help me about that? How do the key terms, where do they say they also use key terms for them?
So the keywords that were described
keywords.
The search terms that were described by Hardy were the search of the CRS. It is not clear if the ELSR indices were searched, what keywords were used for those. We don't even know which systems were searched, the ERS, the EDA, the EDMS, the field office ELSR search. And that matters because the FBI policy had been that when they conduct searches of the ELSR indices directly, they would only search for the subject of the investigation, not mentions or overhears or any of the other things that the ELSR search program is capable of doing. I see I'm now into my rebuttal time.
Okay, thank you.
Good morning. I'll start by focusing on the issues that appear to be of importance to the court. That is the Rule 56D issue, unless there are other questions. Pertaining to that issue, I think the district court's decision has to be read in context. That is, the district court did say there was no showing of bad faith, therefore plaintiff was, or Mr. Shapiro was unentitled to discovery. However, the standard in FOIA is that discovery is the exception, not the norm. That is, if the court has before it sufficient facts to enter summary judgment, it does not abuse its discretion by foregoing discovery and entering summary judgment. In this case, the court had before it sufficient facts to enter summary judgment on the ELSR search issue. Specifically, the second declaration of Mr. Hardy said that the subjects of the request were searched. an ELSER search was done for the subjects of the request and attached as an Exhibit A the subjects which identified the particular names of individuals or organizations. In the 16th Hardy Declaration, Mr. Hardy clarifies that there was a misunderstanding within the FBI in terms of the RIDS office and the ELSER office. They did do, and the ELSER office did do a search. It just turns out that the search was duplicative of what the FBI had already done. That is, that the ELSER indices had been incorporated into the automated case system, which is the general search that the FBI does, which allowed the FBI, by using the search terms, to search the ELSER indices to determine whether there was any potentially responsive information, and if so, then go out and locate that information for purposes of processing.
Mr. Tillman,
Yes.
could I ask you to step back, for example, just for a second, and help me understand all these different indices and systems?
Yes.
And let me try and let me work with an analogy and see if you think it works. Okay.
Yes.
Let's assume what the FBI is operating here is a library. Okay.
Okay.
And it consists of three things. It consists of books, which are the actual case files. The consists of books, which are the actual case files, and as I understand it, that's the ERS, EDA, CRS, and ECS systems. Those are files. Those are books. Those are the books in the library, right?
Yes. Yes.
Okay. And then they've got different kinds of catalogs, as I understand it. Kirk, just tell me if I have this wrong. I may. So the card catalogs are the general indices and the ELSER indices. And in those indices, you can look up books by title and author, right? That's what you use those for. And then there's this computer system, ACS UNI, which allows you to digitally search the card catalogs, right? Is that the way it works?
Generally speaking, yes, but with one caveat, that is that the ELSER indices are incorporated in the automated case system and Sentinel, which is the new generation search feature, which allows you to search the indices. Go ahead.
Wait, say that again, please. What's incorporated into what?
The central record system is composed of, it's just a record system for the FBI. Yeah. And then you have the indices that are incorporated into these search functions. That is the automated, what was previously the automated case system until Sentinel came online on or about 2012. And when that came online, the indices are searchable. The card catalogs, as you call them, are searchable in Sentinel. In Sentinel, and automated case system as well for older older records.
Is that ACS UNI? Is that what that is?
Yes, ACS is the original automated version of the automated
and now that's
index.
Called Sentinel.
That's correct. However, I think ACS was still operational for a period of time. And so it might have been ACS at the particular point in time when the search was conducted, because the declaration was signed in 2012.
Yeah, but, right. Yeah. Okay, great. That's because that's what's mentioned in the declaration.
Yes, yes.
Okay. So given that, I just have two questions. So the first one is, where were ERS and EDA? Those are two record-keeping systems that the plaintiff here says should have been searched. Where do they fit into this whole system? My library system. Where are they?
Well, those. So, in essence, that doesn't.
What are they?
That the so the ELSER indices are what allows you to.
No, not the ELSER. I was actually talking about ERS and EDA. What are they?
I believe that those are actually what systems that maintain records, as opposed to the indexes of records which the indices shows you where to go. If to put it
No, I
simply.
get that, but are these like books in my library? ERS and EDA, are they books?
I believe so, but I would need to clarify. I believe they
Okay.
are.
All right.
But
Okay.
Mhm.
Yeah. Okay. Well, let me ask you this then. Are there any records? Would the records in those systems show up in an ACS UNI search?
they would show up on the indices. They should show up on the indices. That is that if
Oh,
you
then they
recall,
would, right? Because the UNI, the ACS UNI, that would search my card catalog, correct?
that's
In other
correct.
words, they would show up in the card catalog. So they would do
Yes.
that. And is there anything in the declarations that would tell me that? Where would I look to have that? And I realize there's a lot of declarations. If you want to
Paragraph
tell us
one,
later that.
paragraph
I'm sorry,
115,
paragraph what?
115 of the 16th Hardy Declaration.
Uh-huh. Okay, got it. 115. Okay. Here's my second question. It has to do with these ELSR mentions that the plaintiff here has raised. So the second Hardy Declaration says that they're not indexed in the headquarters ELSR index.
That's
So
that-
how? So would the would the ACS UNI search have turned up ELSR mentions that might be listed in field office indices?
yes, and just to clarify,
And
so
how-
there was a misunderstanding in terms of what the ELSR office was doing when it was conducting the search. Initially, in the second declaration, it was believed that the FBI would do the ACS search, but then also send out a request for the ELSR office to do a separate search, which was done in this case. However, the 16th Hardy Declaration clarifies that in essence, what was being done is just searching ACS. That is, the ELSR office was searching ACS because all of the indices, the ELSR indices, were uploaded into ACS.
Okay, I got that. But what about the Hardy? Hardy says that he said some field offices continue to include the names of individuals mentioned in monitored conversations in their field office ELSR indices. Now, those I assume the ACS UNI would find those. But what about the field offices that don't put them in their ELSR index? The ACS UNI search would not find those, would it?
Presuming that they were not put in, but the presumption is that they actually are put in terms of the indices.
But Hardy says some field offices, some continue to include the names of individuals mentioned offices. That suggests to me that others just keep the information in their books, their case files.
That's assuming. I'm sorry, go ahead.
No, go ahead. I didn't. You know.
Again, that was based on the misunderstanding of how the process worked, which was clarified in the 16th Hardy Declaration. In essence, it was
okay. So just step back and explain to us, using the record, how the searches that the FBI did would uncover mentions in field offices that are both mentioned. Some are in the ELSR index, some are just in books. Now, what in the record tells us that the FBI searched for those ELSR mentions, those two categories?
The paragraph 115 of the Hardy Declaration, that is, when you read the declaration, it speaks to the misunderstanding of there being a need for a separate search. However, the indices themselves The indices themselves were uploaded into ACS. And also, I'd like to mention that the standard under FOIA is adequacy. That is to conduct an adequate and reasonable search. So you don't have to recover all records extent. It's that the search has to be reasonable. And there wasn't any challenge below to the adequacy of the search. So that argument was waived. The challenge wasn't to the specific the names used or even whether everything was searched. The Rule 56D motion was, in essence, says that I have insufficient information to challenge the search.
And I want to get to that.
Wait, did you just, is it your position that his challenge to the Elser search is waived? Is that what you just said?
Yes, that's one of the positions. That's correct.
But he, in his cross motion for summary judgment, he said that the Elser search was inadequate for all the reasons said in his other motion, and the court should grant summary judgment based on that. So he raised it.
Well, he didn't raise the precise issues pertaining to the location search in terms of ACS. So the precise issue was not raised before the court.
I see.
That is the issue I'm mentioning to you now that the district court found. That is that the search was adequate because the proper places were searched.
Okay, unless my colleagues, well, did you have anything else?
So I have a question, and that's regarding search terms.
Yes.
I mean, we've held repeatedly, going back to at least Oglesby in 1990, that in order for the district court to assess whether a search was adequate, the court needs to know what search terms or keywords were used. Do you dispute that that's our case law in this circuit?
I do not dispute that fact. In terms of that search terms, that this court has found that search terms are necessary to be able to evaluate the adequacy of the search. So
where in the record were the search terms ever disclosed to the court and to Mr. Shapiro?
The second declaration speaks to the search of the Elser, an Elser search being conducted of the subjects. That is the subjects of the request. That declaration also attaches an Exhibit A, which has as one of the columns subject. In addition, the 16th Hardy Declaration discusses the duplicity of searches. That is, that when the search was conducted, the FBI had already conducted a search of the ACS. And so the FBI's or RID's search of the ACS, which is discussed in the district court's opinion, discussing, as Judge Tatel said, the phonetic breakdowns, the social security numbers were mentioned, as well as the subjects, constituted a search of the what was a search in the search terms used for the Elser indices. Those are the locations in the record where it mentions the information that was searched in the search terms.
I guess what I'm trying to get at, though, is was there ever a list that was provided in the record of, okay, these are the search terms that were used, and here's the list. There's 20, there's 30, there's 40, there's 100, there's 5.
If you look at again, not explicitly, it said we searched the subjects, and so the Exhibit A contains a list, and that list is the list of subjects for each of the 81 different request numbers associated with the request.
Okay, so
not to mention it, as well as the FBI did, the record does spell out what search was done of the ACS in terms of in detail, in terms of the search terms, and that in fact was a search of the Elser indices as well.
What page is that on, Mr. Tillman? in the record.
What specifically? The page of the opinion or page of the declaration, or what do you, what specifically are you?
Yeah, in the declaration.
So the declaration 115, paragraph 115 of the 16th declaration, the second party declaration is an attachment A. The specific paragraph number is 21 in the second declaration. And then the as well as the paragraph 19 of the second declaration. When read together.
Okay. Judge Wilkins, were you finished with that line of questioning?
Well, I guess why I'm confused about this is that in the opening brief of Mr. Shapiro, Appellant Shapiro, Dr. Shapiro, I should say, he points out that the searches weren't adequate, or there's no way to know whether the searches were adequate because we never got the keywords or the search terms. And I didn't see in your brief where you responded to that and said, yes, we did give them the search terms.
And
did I miss that?
Excuse me?
Did I miss that? Is it in your brief?
I don't have a specific place in the brief where that is mentioned. I will confess that I didn't draft the brief, and I wasn't counsel below. But with that being said, it is in the record in terms of the court understood the search terms to be what has been mentioned. The court's opinion discusses the search terms that were used and the searches being adequate.
Okay. Those are all the questions I had.
Judge Rao, did you have anything else?
I did not. Thank you.
Okay, great. Okay, thank you. Let's see. Mr. Light, you had some time left, so go ahead.
Thank you, Your Honor. I think part of the reason that the court is having some difficulty extracting from the record exactly what these systems are about, how they work, what happened, is precisely the reason that we needed discovery and why the record was inadequate. The district court assumed that when the FBI was talking about the ELSER indices, that it meant the ERS and EDA. The FBI never so much as mentions ERS or EDA or field offices or EDMS anywhere in their brief. They suggest at first that they did.
Now, those are all files, right? That you're mentioning.
Those are.
You put them in the context of my library metaphor. Those are all books, right? They're files of documents, correct?
Well, they're audio recordings, but
that's what I mean. They're not card catalogs, right?
They yes, they are catalogs. And if Your Honor would like to see, for example, we included in the record a search request for ERS and the results of it, and what a search slip looks like for EDA and what it returned. And those are at Joint Appendix 526 and 528. The FBI suggested at first that they did a separate search of the ELSER indices, whatever that means. They didn't say what keywords they were using. They didn't say which of the ELSER indices they were searching. And then they go on to say, well, actually, we never searched the ELSER indices separately. what the ELSR folks did is an ACS UNI search. But then that raises the question, all right, the ELSR, the EDA has the capacity to search only
But
principals.
wait, why wouldn't the ACS UNI that searches the ELSR indices, right? That's the way you do it, correct?
Some of
Why would you, if you do, let's assume you're looking for one name and everybody agrees it's the right name.
Okay.
And you put it into UNI, ACS UNI, and it doesn't turn up anything in the ELSR index. Doesn't that tell us that that name's not there?
No, all it tells us is that it is not indexed in the CRS. So what Mr. Hardy says is, and this is at Joint Appendix 155, not all names of individuals contained in the ELSR index can be retrieved through the general indices of the CRS. That is, not all names in the ELSR indices can be retrieved through an ACS UNI search. The government is saying, yes.
And where are those? Yeah, I understand your point about that. I get that. Where are those documents if they're not are they in the office, the field offices? They're just not indexed at all?
They can be indexed. I mean, Your Honor, it's difficult because the record is so incomplete as to what's going on here. And that's sort of why we wanted to get a fuller explanation from the FBI. Mm-hmm. However, the best of my understanding is that the ACS UNI can be searched and that will locate things in the CRS. There is
good. Right.
Okay. Separately from that, there is ELSR, and that is where the actual audio files reside, and it also has its own separate index. So, for example, if the CRS says we did a wiretap of somebody, okay, the actual recording of that is not in the CRS unless it's serialized. Sometimes it is, sometimes it's not. And this is another issue that the FBI doesn't address. When they're serialized, the record shows that they're going into something called a 1D file. If they're not, then everything exists in the ERS EDA, except maybe some of it is in the EDMS, because that is what is currently the most comprehensive system. We don't know what keywords were used, and we don't know if an ACS, assuming the government's position that ACS search did search all of the ELSR indices, we still don't know, did the FBI follow its previous policy of limiting searches to principals, or is that even something that ACS has a capability of doing, distinguishing between principals and mentions? We just have no idea what was going on here. And we asked, I think, some very specific questions in the interrogatories to get at these answers, a little bit about how are things indexed. But I think the court did make very clear in Campbell, which post-dated when the ACS came online, that a separate ELSR search is required. I don't know exactly what the record was in that case. Maybe the government's offering more, maybe it's offering less now. But the record is just so barren that the district court was left to speculate as to what was going on. Some of those speculations may be accurate, some of them were not. But on summary judgment, all of this has to be drawn in the light most favorable to plaintiff. And that's clearly not something that happened here.
So what's your response to your friend on the other side's argument that the district court knew what keywords were used because there was the Exhibit A to the second declaration, and that was explained in paragraph 15 of the 16th Hardy Declaration, etc.
Right. The district court knew what keywords were used to search the ACS. The court did not know what keywords were used to search the ELSR indices separately. It may have been that there were no search terms provided for the ELSR indices because the FBI never did a separate search for the ELSR indices. They said at first they did, they said later they didn't. If they never did a separate search of ERS EDA, our argument is they should have. If their argument is that they did do a separate search of those, then our argument is, then tell us the keywords that were used, tell us what limitations. And I think it is in stark contrast to the incredible detail the FBI provided about how the CRS system works, how it's searched, what keyword terms were used, and their complete silence on the ERS and EDA systems. The court held in Ancient Coin Collectors Guild, essentially that the plaintiff needs to point to a system in the record, and then the burden is on the agency to fill in the gap in the record. And that's what plaintiff did here. Plaintiff did his best job to present information he had from the public record, from previous FOIA requests. But as this court noted in Londrigan, discovery is especially important in FOIA cases because of the asymmetry of information between the parties. And I think it's very telling that the FBI never so much as mentioned these record systems, never mentioned the field offices. And if they did search only the ACS, they never said whether it was limited to a principal search, as their own guidance says should happen. Maybe that guidance was still in effect. Maybe it wasn't. We don't know. The guidance.
Are you disputing what your friend on the other side says, which is that the ACS was searched and that all LCERT indices are uploaded in the ACS?
Yes, they're not uploaded. The actual audio files are sometimes serialized and put into a 1D file, and often they're not. They are in the EDMS or ERS. There is apparently, the FBI says, a quote, interface between these systems. We don't know what that means, right? It may mean that ACS interfaces with it in the sense that it can only access principal records. But the problem here is that we know so little about how these interface and what can be accepted. What we do know for certain is that a search that is limited.
I think I'm not understanding you, or maybe we are like two ships passing in the night. Are you disputing whether LCERT indices are uploaded into ACS indices?
Yes.
Then what is you basing that dispute on? How is that a dispute of fact at this point?
So this is from Joint Appendix 155, the Second Hardy Declaration, saying not all names of individuals contained in the LCERT indices can be retrieved through the general indices of the CRS. The Hardy goes on to later say that RIDS uses the CRS search to locate LCER records. So those are, when they say ACS search, that is equivalent to saying we searched the CRS. And there are LCER records, to be clear, there are some LCER records in the CRS. There might be a record that says, we did a wiretap, here's our Title III application. The FBI would then presumably follow that lead and go to the LCER system to retrieve it. But it is very much in dispute whether they were uploaded, and if they were uploaded, how the search would take place. What would that mean that they interface? And I think it's important also, again, when the FBI says the LCERT indices were uploaded, we don't know what that means. We don't know specifically. LCERT indices is a term that exists in the Federal Register. It's not an actual thing. It's a system of record under the Privacy Act. The actual computer systems are ERS and EDA. So this is a little bit more like a legal conclusion that they're pushing. They made the definitions of LCER indices. They refused to tell the court what their definition is. And that's sort of the basic information that plaintiff needs in order to be able to meaningfully challenge the issues here.
Anything else, Judge Wilkins?
Well, I guess what I'm trying to, another part of this that is concerning to me that I'm trying to tease out is that your Rule 56D motion says, we want discovery because we don't know, in part, and it said the basis was we don't know what search terms were used. With respect to your opposition to summary judgment by the government, you said in passing in a sentence, if we want you to deny summary judgment to the government or grant us summary judgment, I'm not sure which, because of the fact that we don't know what search terms were used as mentioned in our Rule 56D motion. But as best as I can tell, that was never developed further. Am I wrong about that? In the summary judgment briefing, it wasn't developed further.
Yeah, the summary judgment briefing just incorporated by reference.
We've said you can't do that, though.
The court has, I couldn't find any authority that suggests that two concurrent filings cannot incorporate references by each other. What cannot happen is, a plaintiff can't do something that would sort of go over the page limit, or in a separate proceeding, like on appeal, say we incorporate that. But in fact, the government did the same thing in their brief, attempting to incorporate by reference. Their cross motion for summary judgment said nothing other than we incorporate by reference our opposition to the cross motion for summary judgment.
Well, they incorporated by reference their summary judgment motion.
Right.
So you don't have to, when you're briefing summary judgment, and you say, I'm entitled to summary judgment, and then you can say in opposition to the other side's cross motion for summary judgment, you can say, I don't need to say anything more than what I said in my motion saying that I should get summary judgment. That's different than incorporating by reference a completely different motion, which is I want discovery.
Well, I mean, Your Honor, it's not uncommon that plaintiffs argue in the alternative, we need discovery because we don't have the information. But then in order to avoid waiving the issue on the merits, they then say, the same reasons. We could have copied and pasted most of that brief. I don't think that would have really accomplished anything. The reasons we set forth
would have accomplished placing it before the district court, because the district court didn't seem to be focused on your search term argument as a grounds to deny summary judgment. The district court seemed to be focused on your search term argument as whether or not that entitled you to discovery. And the reason that the district court was focused on it that way was because that's the way you litigated it.
Well, I mean, the court ultimately didn't really address the merits of it. So focusing instead entirely on the bad faith. But the way we litigated it in this particular circumstance is to say in our discovery motion, the government's affidavits are insufficiently detailed. That is also the same standard for us to prevail or to successfully oppose their summary judgment motion. If it is true that it was insufficiently detailed, that same argument applies in both cases. So I'm not sure what else we would have said in our brief.
All right, thank you. Those are all my questions.
Thank you, gentlemen. The case is submitted.
Case number 21-7070, Capitalkeys LLC appellant versus Democratic Republic of Congo and Central Bank of the Democratic Republic of the Congo. Mr. Hetman for the appellant, Mr. Werner for the appellees.
Good morning, Your Honors. Robert Hantman for Capitalkeys, the appellant. I wish I could be there in person. My best argument, frankly, is the record below. It's absolutely undisputed that this contract, which was signed by the acting governor, was in 2013. $600,000 was paid, undisputed. Mr. Mutombo, who now has risen after 3 years of litigation, he was also on the bank of Central Bank at the time. He never said a word. I think what's undisputed here is that after the contract was signed, there were no objections to the authority of the person who signed. Nobody did anything. But even worse, Your Honors, which is unbelievable, in litigation, there were 3 years where there was fighting over getting a default, 3 years. And the district court judge and the magistrate were very diligent, making sure that the Bank of Congo and the Congo were notified of everything. Not one peep, not one word contesting the contract. In fact, during the period of time of the 3 years, even before the 3 years, it's undisputed in the record, the members of the Congo came to Washington, D.C. They met with Adam Falkoff. Adam Falkoff corresponded with them. They even said that he did a great job. Undisputed work was done. It's undisputed. And there's a letter from the head of the International Monetary Fund, and if it's A41, in which the head of the Monetary Fund tells the president of the Congo to pay the bill. It's undisputed in the.
Mr. Hammond, if you could maybe focus on the legal issues here about the waiver of foreign sovereign immunity and whether there was actual or apparent authority to sign the contract.
Okay, Your Honor, number one, the actual authority was that the head of the Central Bank of the Congo, he signed, okay? There's no question that he was the authority. Now, at the same time, Mr. Mutombo, which really, he's not even with the government anymore, okay? He was present during the.
Can you hold on a second? Just to get an answer to Judge Routh's question. You're now talking about actual authority, right? And you say and what's your argument that he had actual authority to sign this?
Number one, he has authority to sign for different contracts, okay? He has actual.
But it says,
authority.
The statute says he has authority to solely or jointly sign contracts concluded by the bank. That means authorized by the bank.
Well, he was signing on behalf of the bank. Number one.
Would you please look at I'm looking at Article 31. Okay, would you just look at that language and focus on that? It says he's authorized, the governor has authority to, quote, solely or jointly sign contracts concluded by the bank. To me, that says if the bank has approved a contract, the governor can sign it. So it requires approval, and I don't see any evidence in the record that the bank approved it.
Well, Your Honor, quite frankly, there's absolutely no proof that they did not approve it. There's a suggestion.
Will you just focus? Do you agree with me then that this statute, this governing statute, that you agree with me that the governor only has authority to sign a contract approved by the bank, right? Do you agree with that?
Yes, he can sign day-to-day contracts, which are not a question. This type of contract, he would need the approval of the bank, but to find that he did.
So where is that in the record? Or is there any evidence that the bank approved it?
Well, simply, it seems that it would be absurd that the bank or the commissioners were aware of this in 2013. They never asked for the money to be paid back. They never complained that the governor didn't have the right to do it.
Those facts may go to apparent authority, but I mean, on the actual authority, I mean, is there any evidence that the governor had the authority of the board, the approval of the board to sign this agreement?
Well, but Your Honor, if I may, there's no proof that he did not have the authority. And let me say this, okay? If he did not have the authority, how come from 2013 nothing happened? How come from 2015 for 3 years?
Counsel, would you agree that under the statute in our case law, you have the burden of, at least of production, of establishing that there was a waiver of sovereignty? Right?
Okay, well, number one,
legal
okay, you say that we have the burden of proof. Actually, in Mr. Falkoff's testimony in court, he said that people from the Congo came over to the United States. Okay, he corresponded with them. They wrote him a letter. If you look at the record, it's voluminous, but it's very detailed. They wrote to him, telling him thanking him for what he did. Okay, that meets the burden. Then the burden shifts to the government or to the bank to say that all this didn't happen. You can't ignore the fact that there were representatives that came over here. Okay, the people who wrote to Mr. Falkoff, they never asked for the money back. Why did they ask for the money back? Why is there nothing in the record, absolutely nothing on official stationery to show that the Congo or the central bank to this day is questioning this? The only person who's questioning this is Mr. Mutombo. And Mr. Mutombo, he was in the United States. He met with Mr. Falkoff. This is the gentleman who's now saying that there was no authority, but he was in the United States. Okay, you know, it behooves really credibility that 5 years would go by and not one person says a word about anything. Now the magistrate judge, he found that that this case should go forward for a default. The district court judge initially found that there was a basis for a default. Then there's a motion to dismiss after 5 years from the time of this contract that you're saying maybe it was not authorized. Somebody could have said it's not authorized. Nobody ever did. And then after the lawsuit was filed, nobody even put in an appearance. The State Department was never notified. The judge was never notified. And now you're saying that a United States company that undisputedly raised over $320 million, okay, under our unjust enrichment, shouldn't get paid? If you look at the complaint, I'm sure you did, under the unjust enrichment, there's over $300 million, which was substantiated in part by the head of the International Monetary Fund. It's an exhibit to the complaint. This was all ignored by the court below, Your Honor. The record evidence is clear. To come back and say, well, there's not really proof that this was legitimate after 5 years of not anybody saying it's not legitimate defies reality. Again, this wasn't a summary judgment. This was a motion to dismiss. In a motion to dismiss, you have to accept everything that the plaintiff has submitted. But you don't have to take the complaint. You could look at Mr. Falkoff's testimony. He testified at length. So again, you're asking me a negative. How can we prove that they had authority? There's more than enough evidence here to show that they had real authority and definitely apparent authority, okay? Now, there may be a dispute in different districts over what constitutes apparent authority or non-apparent authority or real authority. Here, we think there was authority for both. But you know what? If there's any doubt, why not just remand it for discovery? And then we can find out exactly what more details you need. But on a motion to dismiss, where you're accepting everything that's true, and you have documentation here, not just from Mr. Farquhar, but from the head of the International Monetary Fund, and say, well, we think there was no real contract here. If there's no contract here, there'll never be a contract. No entity, no foreign entity can have 5 years of not questioning something, pay $600,000, make continued promises to pay, and then say, well, we're still not convinced that there really was a contract. They're in action alone.
Mr. Hinton, you're over time. Unless my colleagues have any questions, we'll hear from the bank.
Thank you.
Mr. Werner, I believe you're muted. On my screen, it's still showing that you are muted.
Okay. Can you hear me now?
Yes.
Yes.
Okay, sorry about that.
Mhm.
Good morning, may it please the court. Paul Werner on behalf of the Central Bank of Shepherd Mullen. I'd like to start, if I may, with Judge Rao's question about actual authority and this idea that there's no proof that the governor did not have authority to enter this contract. In fact, there is very much proof that the governor did not have authority to enter the contract. We put an official version of the law governing the bank into the record, which makes abundantly clear that the governor has no authority to enter a contract like this without approval of the board. We also put into the record declarations from the head of the bank's legal department and also the then current governor of the bank, which confirms that the bank did not give the governor authority to enter any agreement with Capitalkeys, which was necessary, as the district court pointed out, in a contract that sweeps far afield of the bank's purpose to stabilize prices and control the bank's, the government's monetary policy.
What's in the evidence?
I'd also like
the
to
record as far as evidence of who paid the $600,000 and how it was paid?
Sure, Judge Wilkins, there's only one piece of evidence related to $600,000 payment that supposedly was made. It's at A37 of the record, and it is an invoice from Capitalkeys to the DRC. Importantly, it's not to the central bank. Also, I'd point out that that invoice came some 2 years after the contract was entered. The contract was entered, according to the complaint, after this payment was made, but curiously, there is no credit in the contract for the supposed payment, and there is no evidence in the record that the payment was actually received. There is nothing, for example, from Capitalkeys showing that it received any payment. There's only at A37 an invoice that's 2 years after the agreement was supposedly executed. But turning to the apparent authority
Mr.
issue,
Werner, I had a question. Is there any evidence that contracts of this nature are usually approved by the board?
Yes, Your Honor. There's no evidence one way or the other from Capitalkeys, but again, we did put into the record declarations from the governor and the head of the legal department, making clear that these types of contracts do in fact need to be approved by the bank. And as Judge Tatel pointed out in the earlier discussion, the plain language of the law at Article 31 makes very clear that it's framed in a past participle way that makes clear that the governor can sign contracts that are concluded by the bank. And there is no evidence that this is a contract that was ever concluded by the bank.
Mr. Werner, why does this contract not fall under Article 30 of this statute? Right, that the second clause, the governor can confer special powers or one or more representatives. He determines their duties, remuneration, or compensation if applicable. Why is Capitalkeys not a representative that has certain lobbying or consulting duties under Article 30? And because Article 31 does not apply to to things concluded under Article 30?
It's pretty clear that article wouldn't apply for a couple of reasons. One, this is not the type of contract that the governor could ever enter because it's not consistent with its primary objective. And also, based on the allegation of the complaint, this is a contract that purports to guarantee the debts and commitments of the DRC, which also the governor is prohibited from. So I don't think even accepting that article would apply. This is not the type of contract that the governor could ever sign off on. But I don't think that there is really any understanding or any evidence to suggest that Capitalkeys is somehow being authorized to act as an agent of the central bank.
Well, according to
If anything,
Capitalkeys, it says that it was, asked to represent the bank before, different government bodies in the United States or certain international bodies like the IMF. So it's a kind of representative. Maybe.
There's no evidence. As the district court pointed out, there is no evidence, not a single iota, that Capitalkeys ever did anything to the central bank, whether as an agent or otherwise. But this is the type of lobbying and other services agreement that to the district court's mind, and I think is appropriate, really does sweep in to the type of act that would need to be approved by the bank, because it is so far reaching and it goes far beyond the bank's central purpose of simply stabilizing prices and controlling the country's monetary policy. If I can touch,
I do have one other question about this. So if, assume just for the sake of argument that I think this statute regarding the bank is somewhat ambiguous. In the Congo, does the president have the ability to interpret this document or to direct, the head of the bank to take certain actions?
No, the president does not. The bank is an independent agency and jurisdictionally distinct from the government. And it's very clear, and I direct the court to earlier articles, Article 16. It's very clear that the president cannot influence or direct the bank. The bank is independent. It's, of course, its shares are owned ultimately by the DRC, but it is independent, and there's no evidence that the government controls or dominates the central bank in any way to develop that kind of principal and agent relationship.
Could the president do that type of supervision or direction of the bank through an ordinance or an edict or something like that? I'm not saying one necessarily existed. I know that's disputed between the parties, but could the president do that through an ordinance?
Sure, I think that's possible, and that really gets to the Themis case that the appellant raises out of the New York District Court and then the Second Circuit, where there really was an ordinance. And that's important because that's a very clear distinction from what's going on in this case. There, the court found that there was authority because there was a specific ordinance on the book that directed the finance member to implement an agreement and carry it out. But here, there is no ordinance. Now, there's been a lot of discussion of letters from the Congo. There is no letter from the Congo in the record. In terms of the apparent authority, Mr. Hammond points to the court today to the same types of things that the district court properly found were insufficient to establish any apparent authority, because none of the pieces of evidence that are pointed to have anything to do with the bank or any manifestation from the bank to the governor or any manifestation by the bank to Capitalkeys that the governor had authority to enter the contract. There's an invoice. The invoice was directed to the Congo, not to the central bank. There's no evidence that the invoice was paid. There are vague references to members of the Congo, none of whom have ever been identified. There's a reference to the IMF. Of course, the IMF can't manifest to Capitalkeys that the governor has any authority to enter a contract on its behalf. And again, there's this letter from the Congo that we've heard a lot about and yet have never, ever seen. I'm happy to answer any further questions. Thank you, Your Honor.
Judge Rao, nothing?
Nothing further.
Okay, thank you.
I just had one factual question.
We're not done.
Are the French and English versions of this law both authoritative in the Congo, or is only the French version authoritative? Ms. Warner.
It is an official translation, but I don't know specifically. I'm happy to submit further information on that. I do not know off the top of my head. One last point. There was an argument, Mr. Hammond, to the effect of, well, this should just go back for further discovery. The district court below exercised sound discretion to deny discovery. And of course, this court has affirmed many district courts that deny discovery in FSIA cases for sound reasons. Here, Capitalkeys never came forward with any good faith belief of any specific information that either bore on the commercial activity or the waiver issue, and the district court properly found that any relevant evidence would be in possession of Capitalkeys and not necessary to obtain from the central bank. With respect to waiver, any manifestations from the governor to Capitalkeys, from the bank to Capitalkeys, of course, would be in possession of Capitalkeys, and it would have information related to whatever commercial activities it purportedly undertook here in the United States, or any evidence that the bank undertook any commercial activity in connection with the contract in the United States, which it did not. Thank you, Your Honors.
Thank you. Mr. Hammond, you were out of time, but you can have 1 minute. One.
Mr. Hammond, you are muted.
Okay, if you look at the appendix A-147, you'll see a litany of details, okay, which are undisputed at this point, which show that the person who now, after 5 years, is alleging somehow that the acting president at the time of the bank or the commissioner didn't have authority. He was here, he traveled here, he met with Mr. Falkoff. If you look at A-147, undisputed evidence that this gentleman, to this day, he has nothing to do with the Congo. We don't even know whether he's authorized to have done this on behalf of the Congo. There's not one document from the official government or from the bank which supports the defendant's position. There's nothing. There's nothing whatsoever, zero. And if this court were to allow this ruling to stand, no company in the United States will ever have any opportunity to get paid for services they rendered. And here there's over $322 million, $352 million, which was delivered as a result of Capitalkeys services. And you have the letter from the head of the World Bank urging the money be paid. That's not proof.
Okay. Mr. Hampton, thank you very much.
Thank you. Thank
Case
you.
is submitted.
Thank you.
This honorable court is now adjourned until Monday, February 14th at 9:30 a.m.